And welcome, folks. This is House Corrections and Institutions. It's our 2:00 meeting on April 23rd, Wednesday. We're continuing our work a little bit on H379, which is the second look legislation and sentencing. And we have Jennifer Pullman here representing the victims view of sorts. So Jennifer, welcome.
Hi, Jennifer.
I'm glad. Thank you for being so flexible with us. Our schedule has been absolutely crazy. You were scheduled this morning at 11:30 to give us the victim's the victim's perspective on this, and then we ended up moving you all around. So thank you. We appreciate it.
Well, thank you, Madam Chair, and thank you, committee. For the record, my name is Jennifer Pullman. I'm the director of the Center for Crime Victim Services, and I appreciate the time to speak on H379. But if the committee would prefer, after listening to the testimony from my colleagues yesterday, as well as the committee conversation, it felt like it might be not a good use of committee time to speak to the details of 379. Is that appropriate?
That's appropriate. Maybe just an overview of.
Yes, sure. Thank you. Again, the bill, and we'll always feel good when I'm validated by Judge Zone and General Valerio, because I was reading that bill and I was thinking, I am completely confused. So to have them come in, again, raise their excellent points, and then just bring us back to the fact that there's not this one-size-fits-all approach when we're talking about criminal justice reform. And that Vermont stakeholders, in fact, the Sentencing Commission, as you were pointed to, has been discussing this particular issue for several years. And I want to thank Mr. Petty for providing you with copies of the Sentencing Commission report. And for purposes of today, you'll find that language on page 18, which is the very last page of that report.
Right.
So just some broad reflections. First, and this will not surprise you, based on the conversations we've had in this committee, this for victim survivors is just another moving of the goalposts. And the state's attorneys shared with me, shared with others, and they have yet to speak to you, but they've identified at least 7 different exit ramps that currently exist in our system in terms of revisiting the sentence that somebody was handed down. And again, the theme that I hear from victim survivors is that at some point, a sentence should mean something. And what I hear is, where is the support for us? Where is the support for us? And we've been in conversation in this committee about that support that either does exist or does not, and what that could look like. And this committee has been very gracious in its time in terms of hearing those issues. And, we've heard about the concerns about earned time, and Madam Chair was here when this all rolled out, and my predecessor admittedly did not do a good job in elevating victim survivor voice. And this committee and Senate Judiciary really made sure that there would be some fixes implemented. But in that process, we've come to this identification that there are problems with our current post-conviction victim notification system. And we've created a plan, thanks to your support, to move this forward and to fix it. So for me, I have to admit the timing for resurrecting this conversation felt a little bit surprising, because we've identified an area that is a real concrete place that we need to focus some energy. And believe me, I get that no victim and survivor is the same. They're not a monolith. And we've had that conversation in this committee. I've done this work for over 30 years. I completely understand that. And for some, finding forgiveness is important. Currently, I would argue that there are opportunities in our system that would allow for that voice to be heard on those exit ramps, whether it be a parole process, whether it be, again, a post-conviction process, a pardon, all those other areas. I see that as being allowed for. But here's who I hear from. And we talked about numbers and we spoke about data yesterday, but I hear from the families. And again, I have to raise their voices because I can't put them through this every time. But I hear from the survivors of Laura Winterbottom. I hear from the survivors of Melissa Jenkins. Some of you may recall she was the teacher who was killed, tortured, killed, kidnapped in St. Johnsbury. I hear from the family of Lara Sobel, who was the social worker who was shot as she was leaving their DCF office in Washington County, where the person who shot her had laid in wait for her after killing 3 other people. I hear from the brothers of Amy Fitzgerald, who was strangled to death by her husband in Chittenden County. And in that, I'm going to reference that case again. And I hear from so many others. Some of you have not been doing this work as long as I, so I will not give you a litany of those cases, but these are the victims that I hear from. I don't hear from victims who feel they don't have a voice when they're looking to provide support for somebody who's been convicted. And there was a question yesterday that around, are there any women serving a sentence for life without parole? And DOC mentioned there were 2. And I'm going to name them as well. It's very public, but I don't want us to hide behind numbers and data. One of those women is Jodi Herring, the person who killed 3 people before she lay in ambush, lay in wait for Lara Sobel when she was leaving her DCF office as a social worker. The other one is Patricia Prue, who with her husband, Alan, was a couple that lured Melissa Jenkins, who thought she was helping them, killed her in front of her 2-year-old son, bleached her body, and put it in a lake with concrete rocks. So when I speak to the victims who are concerned about where their voice is, again, they ask the question, what about us? And the reality is that in Vermont, victims are only a witness in the criminal justice process. We are one of 11 states that do not have victims' rights in our Constitution, and we have no remedies for victims if their rights are violated. So these are the conversations that I have with folks who are in tremendous pain, and I don't have much to offer them at all. So when I do want to mention, and this is the one part of 379 I want to speak to, when I talk about the numbers and the data. The only part I want to speak to were the Section 1 findings and intent, because I have a different perspective on the information that's presented, wherein we are shown to be a state that has a disproportionate amount of individuals incarcerated serving longer sentences. And for me, I have a positive take on that. And because when I look at that, this shows me that this body, through its close relationship and work with CSG over the years, has accomplished what it set out to do, which was to reduce the population of people who are incarcerated, take a look at what reforms we can initiate, and bring that number down. And you have. So when I think about earned time, presumptive parole, midpoint review of probation, the way we've been modifying cash bail, the fact that we as a state, and I think we are the only state that does not incarcerate folks for non-payment of restitution. These are some of the pieces that we have implemented. We don't incarcerate people for misdemeanors. We don't have long sentences for drug crimes. And so that it's proportionally higher is not a surprise to me. And I don't mean to be glib, but for me, I want to say congratulations, because I look at the population that you have, and I've gotten a lot of this information from Josh Rutherford. This will not be popular to say, but it reflects that there are people in there that should be in there. So for me, when I see that disproportionate amount, it's because we don't do things the way that other states do them. And that's why, for me, if we're going to create another exit ramp, it needs to be a Vermont-driven solution that has Vermont experts who are a part of that process. I do want to speak briefly to the proposal, not because we're going to be looking for another bill. It's too late in the session, and we all want you out of here, hopefully mid-May, right? So I just did want to speak to a little bit of the proposal because it's what I'll be pushing for in the off session, and my guess is if we come back, it's what you'll hear from me in some way, shape, or form. The one piece of this proposal, and I know it is a recommendation from the Sentencing Commission. The center has a seat. I was not at the center at that time. It was not a unanimous proposal, and I don't think, as long as I've been on the Sentencing Commission, there's ever been anything that's been, oh no, I take that back. There was some decriminalization of drug possession crimes that were unanimous. But for me, one of the vast improvements in this proposal is that it has the prosecutor as the gatekeeper. I think it's really important to make sure that that role is one that is honored. And until we have criteria established, especially until we do, I'm really sensitive to the fact that without criteria, without the prosecutor as a gatekeeper, victim survivors could be subjected to General Valerio spoke about frivolous pieces, frivolous petitions that just put the family through that, put the survivor through that, put the victim through that. So I think the prosecutor as a gatekeeper is a vast improvement in this proposal. But if you have not had a chance to look at it, or perhaps you have, you may note that the word victim does not appear once in all of this language. So if we're going to do this, the center is going to be working very hard to make sure that victims and survivors have a role in this process. Because right now, this proposal will allow for the modification of a sentence at any time. But there is no right to be heard. There is no right to be consulted. And we have that in current law when it comes to engaging in plea agreements and at the sentencing hearing itself. So there's no requirement that the victim's input be the superseding factor that overrides prosecutorial discretion. But there's a consultation point and a point to be heard. And I mentioned the Fitzgerald case because that really speaks quite loudly to me, in that the person who was sentenced for strangling his wife back in the mid-1990s was sentenced to life without parole. There in Chittenden County, there was a determination by the prosecutor and the defense that they would essentially agree to moving the case forward for parole eligibility, and he would be released on furlough in 6 months. The victims, her surviving brothers, did not find out about this until the day before the hearing. They contacted me after the fact. I had just started this position and were outraged that they were not even told, consulted, and that they found out a day before that their sister's killer would be released in 6 months. It is really important that even if we are uncomfortable with what a victim survivor may have to say, that we allow them to be heard. And so that is something that I really want to, I intend to move forward with. The other piece is, you spoke about this a little bit yesterday, the importance of it being perspective only. And we went through that with earned time and the earned time fix. And for me, and for the center, that's going to be of primary importance. Victims have already entered into plea agreements in these cases or been put through a trial. This was not the law. They understood the law as it was. And to go back on all of those agreements would wreak havoc on our system and on the people who are most deeply impacted. That being said, I'm still thinking about cases that are in the system that will not be resolved before we would make any changes, such as Roberta Martin, the 82-year-old mother and grandmother in Enosburg. If any of these cases are not familiar to you, I invite you to join my world and read about what impact that has had on the families and on the entire community. The other piece that I hope to emphasize is that around the resources issue and the backlog, making sure we consider those pieces. When General Valerio spoke yesterday, they have the Prisoners' Rights Office, and he spoke also about, their post-appellate review sort of unit. I listened to Team Leader Dumont from the director from the Department of State's Attorneys and Sheriff, in his appropriations request. They don't have any PCR attorneys, post-conviction relief. They were seeking resources for just one. That department did not receive that appropriation. They are severely under-resourced. So any post-conviction changes we were to do, we would have to think about what we're going to do to provide a little more of an equal playing field. They don't have something that's the equivalent of prisoners' rights. They have their state's attorneys who are already overworked, and their victim advocates who have 600 cases. So that's a really important piece that, again, there's the policy piece, but then there's the logistics. How are we going to do it? And then finally, just, again, really being thoughtful about that criteria piece. We strive to have a transparent system, and, the brothers of Amy shared, and they shared this publicly too, that for them, it just felt like, well, there was a different prosecutor with a different philosophy who didn't believe in life without parole. So there was that change. They didn't know why, but that's kind of what they walked away with. And there wasn't really that explanation that they shared for me. And when we talk about geographic justice, I'm sure even those of you who are new to the legislature have heard that term, but thinking about, how do we put in place some kind of criteria so that victims and offenders do not have completely different expectations of what they may have received, don't have completely different outcomes based on the county they happen to be in and the judge who happens to be there. So having some sort of guidelines, obviously it's not a box checking per se, but some sort of guidelines feels really important if we're going to have, again, some sort of a transparent system that does not contribute to the perceived geographic injustice that exists in our state. So I'm just flagging these issues because it sounds like I might be back here again next session to speak further on those. And those are the main pieces that I'm going to pursue, which doesn't mean I still might not have issues. And who knows, maybe nobody will agree with me at all. But I really appreciate your time today. And I appreciate the committee's willingness to let the folks who've been doing this work, who know Vermont laws, who know Vermont's procedures, and who know Vermont's culture, to get back to work and come back with some reasonably well thought out proposals for the committee to consider.
Thank you, Jennifer. And as a lot of this was pointed out, a lot of this happens in the courts and the judicial system and not so much corrections. So our focus has really been how many folks are incarcerated that could avail themselves of the language as it's drafted in 379. Yesterday, with the testimony from Judge Zone, the Defender General, in terms of looking at the recommendation that came out of the Sentencing Commission back in 2020. Again, our focus is on the folks who are incarcerated and their length of sentences. The bulk of the work on this particular issue, whichever form it takes, would really be happening in the House Judiciary Committee. And I have notified the chair of House Judiciary Committee that we have this bill, we're looking at it. I did also share with him what the judge and the Defender General recommended yesterday was the Sentencing Commission's recommend in terms of the sentence reconsideration proposal. And if there's any work that's going to be happening on this, it will be happening in House Judiciary. We just don't know when, if it will be whatever's remaining of this session or if it will be next session. So that's where we are at this point. So I just wanted, everyone to be on the same page in terms of understanding what's ahead of us over the next couple of weeks or so.
And thank you. I know that there's no bright line, and I just wanted the committee to know what I'll be up to.
Yeah, we appreciate that.
Jennifer.
Yeah. Questions, Kevin?
Just a comment. In my opinion, the
the criteria that we would use if we were going to do something like this is essential. And obviously, one extreme of the criteria could be, I'm not recommending it, but I'm just saying could be that the victim, in consultation or meeting the perpetrator, is comfortable that it's okay because they have changed. I'm not saying that that is the right thing to do, but I mean, that would be one extreme that would protect the victims, if you will, is that that criteria would need to be met for the second chance to take effect. So someplace in between that one extreme and I like the way this victim or this perpetrator looks. I don't mean to be crass. You know, the criteria I see is the real crux here. So I guess that's just a comment more than anything else.
Because the testimony that we've heard in a variety of different ways has been if the person who is incarcerated committed the crime when they were in their early 20s, and by the time they're in their 40s, they kind of age out, and that should be taken into consideration. And that's what you're getting at,
Right,
right?
right.
Yeah.
And I understand the age component completely. And I also elsewhere in our statutes, we do ask that the court, consider the views of the victim. And again, we're getting into the weeds, but rehabilitative programming is really important. The husband of Amy Fitzgerald denied until this deal was on the table. And then he said, okay, I did do it. So I think those are pieces that I'll work with my colleagues. I love working with them, and we'll figure out what that could flesh some of those pieces out.
The questions, comments? Jennifer, thank you. Again, I don't know where we're headed with this bill, and if we do more work, it may end up being more in Judiciary Committee on the House side. And we are getting towards the end of the session, and their workload is pretty full. So we're just not sure at this point what's going to happen.
Thank you so much for your time. Your committee's been very thoughtful, and kind this session. So I really appreciate the attention to the issues that I've raised concerns about.
And while I've got you, this just came into my mind. I just had a conversation with Representative Lalonde, and they're working on a judicial bill. I think it's a miscellaneous. I think it's S-109. Have you been in contact with them? I know they put in the language that you recommended.
Yes.
On earned time for the 90-day notification to the victims.
Yes.
They are putting that language in that bill, and I would assume they had reached out to you.
Yes, I testified in that committee, as well as the Department of Corrections testified.
Okay. So we'll be looking at that language. I know you presented that language to us probably about 4 weeks ago when we were looking at victim notification. But we'll quickly look at that language because I know you spoke to us about it and presented it to us as well for that.
Thank you. And if any questions come up, I'm happy to speak further or submit an email or a letter if that would be more easier to manage in terms of your time.
Okay, that sounds great. Thank you, Jennifer.
Thank you,
Thank you. I
Jennifer.
appreciate
Thanks,
it.
Jennifer.
Yeah, enjoy the day. It's warm out there.
Yeah, I hope to leave the house. Thank you.
Good luck.
Thanks.
Okay, so I don't know where else to go with second look. The committee is thinking. I did have a conversation with Martin Lalonde about the Sentencing Commission request or recommend about the reconsideration, reconsideration proposal. This is what was handed out yesterday. And there was on my desk, and I'm assuming other people's desks and on our website, the Senate's Commission report. So that's on our website too. That's from 2020. I did have a brief conversation with Martin Lalonde. right after the floor today. And at this point, if there's any further work on this, I think it should be in judiciary at this point. So we could pursue a conversation with judiciary to physically move 379 over there. Or, I mean, that would be a conversation with Martin, with the chair, or we could keep 379 here, but ask them to take a look at the judge's sentence through consideration proposal. So we could do a variety of things. Come on in. So think that through, committee, see what you want to do for that, because I'd like to take care of our dangling pieces that we had, and this is one of them. Is there anything right now that strikes you that we should do? Well, I'll speak up at once.
Yeah, I'm comfortable with the direction of having this conversation, you know, in the off session with the people who know the system well, and I think add insight that we're unable to in this room, you know, that's,
Yeah, I think you were right this morning.
is that 2 for 2?
No, it was the same thing.
Same one, yeah, no.
You get credit for the same thing twice, but you were still right.
Keep the conversation going.
Yeah.
That's where we're moving. I would just want to make sure that Dr. Reese or her designee would be a member on this
Keep the conversation going.
over the summer. If we hand this off back
Who
to,
will we hand it off to?
well, I'm thinking like the Defender General's office. I mean, this feels,
State's attorneys may not be in support of it.
I get that. I get that. And I'm not sure
Would it be worth
don't-
recommending that Justice Oversight take a look at this?
yeah.
It was on the Committee of Justice, well, we don't have the House side appointed. But you have usually the 2 chairs of judiciary are on there. This chair. And the chair of institutions on the other side.
He feels like a better, quote, to use her language, gatekeeper than the prosecutors. Legislative gatekeeping.
To continue this conversation
Yeah.
like summer and fall. We could do that.
I don't know, I'm kind of thinking out loud, so I'm hoping to be challenged on that.
I do agree, and not just because she's in the room, I think.
Yeah.
And Dr. Reese, a part of that with the national perspective is very,
But that would be where the Justice Oversight would
Mhm.
take testimony and work with that. I'm just throwing that out. I mean, we got people, there's people on Justice Oversight that are not connected to corrections. Appropriations,
Are you on? What was that? Yeah.
Appropriations Committee on both sides. Institutions Committee on both sides, Judiciary Committee on both sides. Human Services and Health and Welfare Committee, and then a member at large on both sides. So you've got folks from the Human Services world, and you got Judiciary world. And Ben Novogrodsky is our ledge counsel that works with staff justice oversight. And I don't know who the chair will be this year. I think this time around it's the House's turn to be chair. Last time it was the Senate. Brian,
I'm wondering if you or anybody else here can sort of color how the Center for Crime Victim Services reacted when the discussion was happening with good time or earned time. Like how much of this is a problem with the fuzzy and how much of this is a problem with less time?
what do you mean with fuzzy?
Not knowing exactly what the rules are or worried that things are going to change or having the goalposts moved or the ground under their feet.
It's hard if someone's already sentenced
Right.
and then you change everything.
And she was arguing prospective. Yeah.
Right. And that's what happened with earned time. But it wasn't going back. With earned time, it took effect on a certain date. Once the department had to promulgate rules, those had to go through LCAR, that had to be all approved. So there was time from the time the bill passed and was enacted, but it didn't take effect until the rules were accepted. So there was like a year and a half time, and we wanted to make sure victims were notified during that time frame. Earned time, when it came about, affected, it applied to everyone who was currently incarcerated, but it didn't go back on their sentence. It was from that point forward. And the person who preceded Jennifer Pullman, it was not relayed to the victims in a timely manner that earned time was going to kick in until it kicked in, and then it blew up. It really blew up because the victims were not notified. That was not the legislative intent. So you have to be careful with that, and you have to be very clear. But victims, the feeling is they agree, because most of the sentences are through a plea deal, where the victims can agree or not agree to a plea deal, but they're made aware there was a plea deal, and they know that length of sentence. And then 10 years down the road, you've got initiatives that happen, and then it changes, possibly that end date or the minimum and the maximum, it changes.
So this-
And they give, the feeling is, in the testimony we've received, it's just re-victimization.
Potentially, if it's prospective and if communication doesn't get messed up again, then this would be acceptable, palatable, maybe.
It would be difficult.
Yeah.
Because every time you adjust that sentence,
Yes.
and this isn't true for all victims, but there is saying, hey, we have to deal with this again. In our mind, this person was getting out in 2035, and now the person may be getting out in 2030.
Yep.
Yeah, there's that.
Thanks.
Unless you go to the extreme that I mentioned, that part of the criteria is that the victims are aware and they agree that the person
Mhm.
is not a risk anymore and acceptable, then you don't have that problem. Now, that may be too extreme, but
So that's also part of a parole hearing as well, right now. Victims can participate in parole hearings as well. Some choose to do so and some choose not to. So that's currently what happens now for parole. Victims can go before the parole board and voice their concern that, yes, we're at a different place, this might be acceptable, or they're saying, no. So they do have that in the parole board process.
I think that gets messy too, though, right? Because where do you delimit the victims? I mean, it's not like there's just one in all these cases, right?
Right.
Then who gets the veto, et cetera.
but there's a difference between input
Yeah.
and having the final say.
Yep.
I mean,
Yeah, you want
if
the
they have the
input.
final say, then that takes the victim issue off the table.
I want the victims to have a say. A vehicle for,
Well, yeah.
Well, you want a veto, right?
Step further, I'm not saying just say, they actually get to veto
They have,
the proposal that the incarcerated
I don't know if we could
detainees.
go down that road. I don't know if you could do that, but that's all in the world of judiciary. Eric is sitting there going, oh.
reminder, I think there's some pieces on it in the miscellaneous
In terms of what?
in terms of the earn time. I almost said good
Well,
time.
that's a 90-day notification.
Yeah. Right.
Yeah, and that's what we had initially in this committee when we put in earned time, had talked about a 90-day notification of the victim.
Right.
And it's up to the victim
To opt in.
to opt in. Because some of them don't want to opt in because we've traumatized them. They don't want to know. Or they don't want to know every 90 days. Maybe they want to know twice a year. Or once a year or something. So do we have people on Zoom?
We have Joyce McKean in the
Okay,
waiting.
let's let her in.
Okay.
So let's figure out what we're gonna do on 379, and we can have further conversations with Representative Lalonde. Because really, we're shifting more into the judiciary jurisdiction, their world, not so much ours now. So we're gonna shift gears. We're back to county courthouses. And we have a new draft. So Eric, come on up. And I know the draft has been, we have 3.1 or is there another one, Eric?
I know 3.1 is correct.
3.1 is correct.
Oh,
Well, it's
right draft. I don't know if
It's right
it's
draft.
correct yet.
We haven't changed it yet, but we. And I know it's been shared with the court administrator. It's also been shared with Joyce McKeeman. And so Eric, we had conversations yesterday about the capital program, how it's defined. It was defined in Title 24, Section 4430. We decided to shift all that to 133. And then we also talked about the report back. So Eric, if you can walk us through this and introduce yourself for the record.
Absolutely. Good afternoon again, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. Here, as the chair said, to walk the committee through another version of the proposed amendment to the Judiciary Miscellaneous Bill, S-109, involving capital budget requests for county courthouses. We're on version 3.1. And as the chair mentioned, the language is really connected to 24 VSA Section 133, which you may still have. I believe I'd handed that out yesterday. So it's helpful to refer to that because the proposed amendment language does refer to it several times. But the first piece that you see, remember, this is all part of the process of when an assistant judge makes a request for a capital request involving courthouse or court operations. There's this process where they have to submit that request to the court administrator, who then makes a recommendation about whether to include that in the judiciary's request for the budget bill. So that process is in law. This adds some detail to that process. First of all, makes clear, you see lines 9 and 10, this language is not changed from the previous draft. Well, actually, one word the editors did change, but they changed the word does to shall. So it says does not include rather than shall not include, but no substantive change in the meaning there. So making clear to all the court operations, it doesn't include operating expenses. Then moving on to the new criteria that the court administrator would be considering under this amendments 1, 2, and 3 of page 1. The first one is whether the funding request is consistent with a capital program developed pursuant to, and then there's the cross-reference to 24 VSA 133 E3. And if you look at E3, which is what we were looking at yesterday, you'll see that in the budget that the assistant judges prepare for their county every year, they may include, this is E3, they may include a capital program. So pursuant to a capital program, and that capital program may also include a provision for a reserve fund, a capital reserve fund. So those are both optional, basically. So the proposal here is to basically providing the court administrator with information about whether or not this particular county has a capital program or a capital reserve fund. So B1 refers to the capital program. So whether the funding request, they'd have to identify whether the funding request is consistent with a capital program developed pursuant to the language we just looked at. They may have, they may not have, but the idea is that the court administrator would know that one way or the other. That's piece of information number 1. Number 2, whether the project that is the subject of the request has been included in the list of capital projects in the county's budget pursuant to that would be E1 of the statute that you have on the handout. And if it is included, description of the project. So again, so if you turn back to E1, says, all right, this proposed budget, this proposed annual county budget shall contain, so this one's mandatory, shall contain any cost estimates and preliminary plans for capital construction in the county. So if there is any capital construction plans, then there's got to be cost estimates, as well as if you continue down, some other information has to be in there, estimates of the indebtedness, probable expenses, any other expenses and obligations to the county. So there's going to be some information in there about any of their annual proposed capital construction projects. And if they're there, then subdivision 2 of the amendment requires that it be listed in this request that the county is providing to the court administrator. So lastly, number 3, also I sort of had alluded to this earlier, because within that subdivision 3, besides the option of having a capital program, there's an option of having a capital reserve fund. So subdivision 3 here basically says if you have one, indicate that on your application as well. And if so, the amount of the annual contribution that the county has made to the fund. So again, it's whether the county has established it because it's an option, it's not a requirement. They might not. But either way, the court administrator would have the information.
Questions from the committee on this? This is clear. We really clarified this.
That's really
Yes.
good, I think, yeah.
Good.
Before we move on, I do want to open this up to Joyce as well as Terry. While we're on these, on B, 1, 2, and 3, is this, I think Joyce, are you still reading it? Are you still processing?
No, I've read it over a couple of times before I joined the meeting, so I'm familiar with it. Yes.
Are you comfortable with it?
Yes, I think so. I mean, it'll require, this will require some education among our members so that everybody's aware of what they need to have in place before they make this annual request. And again, I'm a little bit of a broken record, but we haven't used the capital request process that often. But yes, this is all consistent. This is all consistent with what's already in 133E. So
Yes.
we have to abide by that anyway.
And laying it out this way, will that help both the Association of County Judges as well, working with the court administrator to come back with a report in terms of the steps that would be taken and the processes that might be considered, any proposed legislative changes? Is this a good framework for you folks to work through the summer and fall?
Yeah, I was giving that quite a bit of thought this afternoon, and I think it will. I think that what it will serve to do is to routinize among the assistant judges the need for more deliberate capital planning than probably is going on right now. So yes, I think it will facilitate that and certainly provides a good framework for working with the court administrator over the summer.
And Terry, for example, what is your thinking on B 1, 2, and 3?
Thank you, Chair Evans. Chair Trussell, the State Court Administrator. I agree with Judge Hoover. I think this will be very helpful and has a clear framework.
Anything from the committee? Okay, let's keep going.
All right, so as the chair was mentioning, these provisions have a delayed effective date. So skipping for a second over on to page 3, over down to the very last couple of lines, section 34A of this act that refers to the section we were just looking at, doesn't take effect until July 1st, 2026. So that's got over a year from now before those provisions, those requirements of what has to be in these funding requests would have to be there. In the meantime, you have this report. Yeah, so this is some work because you were, as your witnesses were just talking about, some discussions and work that would go on over the summer and fall. And then there would be a report back to you folks in January of next year. And in that report, you'll see, so this is here where the one change that the judge and the court administrator in an email discussion prior to today, and I don't want to put words in anybody's mouth, I think have agreed to a slightly different formulation of the language, and I'll read that to you in a moment here. But so the way the language is in front of you says, for example, the court administrator in consultation with the Vermont Association of County Judges shall report to this committee and the Senate Committee on Institutions on the progress made to implement the provisions of section 34A. In other words, what you just looked at. So progress report on what they've been doing so far, how much they've accomplished, steps they've taken. And then the second sentence, that what does the report have to include? A description of the steps taken and processes considered. And this is additional language, line 9, and any proposed legislative changes necessary to ensure that capital budget requests for county courthouses include the information required by 34A. So it's not only what they've been doing, but also there may be some legislative ideas or thoughts that come to them as they're working over the summer and fall that might be helpful, and they would include that in the report as well. So back up to the first sentence, though, I think that, as I mentioned, the judge and the court administrator agreed that the language would be better framed to say, rather than the court administrator in consultation with, would say, the court administrator and a representative of the Association of County Judges appointed by the president of that association shall jointly report. So it's really just a matter of how are the two parties working together. Is it one in consultation with the other? That's what you have in front of you. But the proposal is that it's more of a joint report.
So it would be the court administrator and a representative of the Vermont Association of County Judges.
Yeah, appointed by the president.
Appointed by the president.
Yeah. Shall jointly report.
Shall jointly report.
Exactly.
I saw the thread of the email thread on this. And Joyce, are you comfortable with this? Because I know that was a concern. It looked like court administrator was going to submit the report, but they only had to consult with the SAG judge, with the association, but it was really the court administrator. The court administrator was willing to take some workload off of the county judges. So,
Right.
what do you? So I saw that thread of emails. Does this language address the concern that you laid out? New language.
It does. Thank you very much, Madam Chair. And I realize I didn't identify myself, and just over the record, I'm Joyce McKeeman. I'm Assistant Judge in Orange County and the President of the Vermont Association of County Judges, just for the record. So yes, once again, I represent 28 members, and there were some concerns raised, and they wanted to feel as if this was more of a joint report. And so the issue of having a representative means that we'll decide among ourselves who the best person will be. Probably will be me, but who knows, to work with the court administrator over the next few months to get the report together. So I appreciate the willingness to change the language a little bit for us.
So it's the court administrator and a representative of the Association of County Judges shall jointly report. I want to make sure that who would actually be doing the work in terms of looking at the implementation of 34A and how it plays out. Would that be just the court administrator and the representative that's appointed to actually do this work on the substance? We're understanding they shall report, but who does the work that would go into that report? Is it just the court administrator and the representative from the association? Because we're silent on that.
Yeah, well, that was my understanding, that it would be a jointly authored report, and then presented by Terry and myself, perhaps, or whoever at the end. So, yeah, in terms of the work, I mean, Terry and I didn't go into a lot of detail on that, and I know she's there if she wants to speak to that.
I think she does. Terry?
I envision, we alluded to it briefly, is I know your group is meeting at Judicial College, for example. And if I'm allowed to have time at that, I thought that would be an ideal opportunity to discuss all of this and gather the information necessary for the report, basically to spell out what the process would be. I envision even developing a form that hopefully would be useful to be used in the event a request is made. But I picture a meeting of everyone and then a report summarizing. And I'm happy to, draft whatever and have much feedback to make it a joint effort would be great.
So it could go in a variety of directions in terms of how you would meet with the court administrator and the judges. It could play out in a variety of ways, but you want that flexibility, is what I'm also picking up.
yes, from our perspective, we would. And, the assistant judges have a great relationship with the court administrator's office. And so, I think I don't anticipate any issues with this going forward.
Okay. I just wanted to make sure, because it's clear in terms of who does the report coming back, who submits.
Yeah, I just have an open question. Is the language too limiting in any way? Because, at the end of the day, the report, the very last line there, include a description of the steps taken and processes considered or any legislative changes to ensure, that 34A is followed with that specific criteria. Is that too rigid not to allow in this discussion new criteria to emerge? Or maybe, you know what, this is rubbish. Let's reinvent something else to propose to them, I'm just wondering if so we've set forth this criteria. Does it put them too much of a box rather than give some creativity there to think of new things?
Well, maybe it includes any proposed legislative changes necessary, that if there were additional criteria or whatever develops, I think that might give us the flexibility.
Sure, Mike, yeah. I just want to make sure you guys feel comfortable there.
I think you've also got your catch-all, page 2, line 13.
Yeah, any other, right. Any other criteria.
That to include, maybe
Yeah.
like they have other ideas for, like you said, hey, this list should include A, B, and C also.
Right. I'm good if everybody else is good.
Other questions? Thoughts? So Joyce, you would support this language going for this new version that we just worked on?
Yes.
Which also includes, it would be a new draft, it would be 4.1, which would include court administrator and a representative from the association appointed by the president, instead of court administrator in consultation for that. And Terry Horzone, court administrator, you're supportive?
Yes, this is fine.
Got some work, committee.
Just fine.
It works. The language works for both sides.
Yep. Hey.
So what I'd like to do.
There you
Right. What you said?
This is perfect.
She always dreamed of legislation.
So this is an amendment that I would offer to to House Judiciary for S-109. So what I would like is a straw vote from the committee on do you need to take a report on a straw vote?
No, not on
I
a straw
don't
vote.
think so. It's a straw vote. I don't think we need a roll call on this, do we?
Checking.
Should we do a roll call on this, folks?
Usually just raise your hand right on the straw vote. It's going back over, right?
It's going over to House Judiciary as a recommendation from us. So I would entertain a motion that we support this proposed amendment to the House Committee on Judiciary. Moved. Second. It's been moved and seconded that this proposal of amendment be offered to House Judiciary Committee on S-109. Is there any further discussion? So all those in favor, please raise your hand.
Aye.
All those opposed? Okay, so it was 10-01. God, we get something out, folks.
Woohoo! Take tomorrow.
Thank you, Eric.
Yes.
This is a lot of work. Thank you, Joyce.
Good work on it.
Thank you, Terry.
Thanks to you all for your work on this.
I think Joyce too, I want to thank you for your candid testimony, particularly when you first came before us. You gave us a lot of insight in terms of the process that county judges go through.
Yeah.
The process of capital budgeting that you folks do, as well as a reserve fund. I think that testimony helped us a tremendous amount. And I know it also helped the court administrator as well. And I really appreciate you being as candid as you were on the first time you came before us, because it really helped us get to this point.
Thank you.
Well, you're very welcome. And, that's part of our job, is to help people understand, what assistant judges do. And this county budgeting seems to be shrouded in mystery for some reason. So once again, I would urge all of you, be watching for the warning. Your county budget meeting will be held in December. And you're all invited in the dark of night to venture out.
In a snowstorm, probably.
Of course, At least in Orange County, we've moved to a hybrid. So we are open for people to come in, but we've also moved to a remote option. So we still don't get very many people, but at least it's easier.
Yes.
So thank you, Madam Chair, very much. Appreciate
Well,
it.
thank you. We really appreciate all your work. Thank you.
Thank you.
And thank you, Terry. That's very helpful too.
Judge McKeon.
So,
Alice, Katie can unexpectedly come earlier. Can I ask her to write over?
let's take a 10-minute break and have her come in.
Just a second, let me break you first.
Yes, we got to get off of you too. So Eric, give me a new draft,
Yes.
or do you want to just give me a new draft?